Generally, a state's Recording Act creates a system for providing the public with notice of property interests and determining the relative priority of competing property interests. To this end, parties may search for recorded interests on the land records by looking through indexes. But what if an interest wasn't perfectly indexed? Does that mean it wasn't properly recorded? The Minnesota Supreme Court considered this question in MidCountry Bank versus Krueger. In March of 2000, Frederick and Nancy Krueger bought land in Belle Plaine, Minnesota. 4 years later, they purchased 2 different parcels of land through a loan from MidCountry Bank. As security for the loan, the Kruegers gave MidCountry mortgages on the new parcels and the Belle Plaine land. In May of 2004, the mortgages and deeds to the new parcels were properly recorded at the county recorder's office. However, the mortgage on the Belle Plaine land wasn't perfectly indexed and didn't appear in the tract index. Specifically, a search of the tract index for the 2 new parcels showed that MidCountry had mortgages that encumbered those parcels. But the same search for the Belle Plaine land didn't show that MidCountry had a mortgage encumbering that land. Nevertheless, a search of the grantor-grantee index for the Kruegers showed the mortgage on the Belle Plaine land. At the time, Minnesota law required the proper indexing of all recorded property interests. 2 years later, the Kruegers agreed to sell the Belle Plaine land to Carolyn Hinshaw without disclosing that MidCountry had a mortgage on the property. As security for a loan, Hinshaw gave PHH Home Loans a mortgage on the land, and the Kruegers conveyed their interest to Hinshaw by deed. A few weeks later, the mortgage and deed were recorded on the land records. Subsequently, MidCountry brought a foreclosure action in state district court against the Kruegers, Hinshaw, and PHH. The parties filed cross motions for summary judgment, and the court granted Hinshaw and PHH's motion, concluding that because MidCountry's mortgage didn't appear in the tract index, Hinshaw and PHH didn't have constructive notice of MidCountry's superior interest in the land. Therefore, the mortgage wasn't properly recorded. MidCountry appealed to the Court of Appeals, which reversed. The Minnesota Supreme Court granted Hinshaw's and PHH's petition for review.